India Confederation of the Blind. Training workshop on the rights of persons with disabilities with particular emphasis on the visually impaired for AICB affiliates in South India. Sponsored by Danish Association of the Blind.
So we talked about various issues which can be taken through advocacy, various rules, legislations, policies. The question now arises, how to do advocacy, how to prepare documents, what are the advocacy documents, what are the tools, how does organizations go about making cases and all that, what are the advocacy records, what is a petition, what is a counter, what does this mean? For that, to address that in those issues, we have a very eminent speaker and a very good lawyer in Tamil Nadu who has done a very important case for us. I would request Mr. L.P.Maurya to take the floor. In 1:15, in 1:05 or 1:10, if you could, 1:07, we can speak, and then we would have some time for question answer. Please take our audience through about advocacy, documentation, and records, and tell us about that very important case that you also done as an implication. Muthu may like to say something more about Mr. Maurya before he takes the floor. Muthu.
To tell about Maurya, actually, he has done some disability, very important disability cases. First, actually, he was my classmate, actually. Basically, Maurya was my classmate. And you all know this, Gopalakrishnan sir from NIVH. Immediately, he was transferred to other state. So, Maurya has intervened and he has immediately got stay, and the court has directed Gopalakrishnan to be again placed in NIVH itself. And another important case he has done for our organization, All India Confederation of the Blind. Again, it was a case against case as per Section 20 of RPD Act. In fact, it was against the Pondicherry Labor Court cum Tribunal. A person was terminated on the ground of his disability. So terminated from the service on the ground of his disability. The court, labor court said that he cannot be, there is no identified post for a person with visual impairment in the labor court. So he was terminated, and our organization has given this case to Mr. Maurya. I think in 1 month time, after 2 hearings, in the third hearing itself, his termination was. Like the court had ordered the reinstatement of the person. So it came before the first bench. So Maurya has done a very wonderful job. So in 1 month time, we could complete this case. Now the person, Mr. Shanmugasundaram, was reappointed, and he is continuing his service. So this is just what I want to tell about Mr. Maurya, and he has been very interesting to work with persons with disabilities.
Thank you, MuthuSelvi, for introducing me to this gathering. Good afternoon, one and all. I wish everyone a good Sunday morning. I think I'm audible. I would like to start by thanking everyone for coming on a Sunday to attend this event. I hope it is as productive for the audience and the speakers. At the inception, I would like to thank Mr. J.L. Kaul, Secretary General, All India Confederation of the Blind, for inviting me to this workshop and giving me an opportunity to share my views on the topic on documents and records. So, at the inception, I would like to dwell upon the topic of, before going deep into the topic, one has to understand the distinction between fundamental rights and directive principles of state policy, and the various writs involved in approaching the Honorable High Court as well as the Supreme Court. So, on August 15, 2022, independent India will turn 75. In the lifespan of nations, India is still young. Independence means we can rule ourselves without any fetters. In order to govern ourselves, we need a set of rules and guidelines by which our nation should operate. Such a set of rules is our constitution. Our constitution, apart from giving the structure and the laws by which the nation should be governed, also recognizes fundamental rights of the people of India, and also lays down the directive principles of state policy. Part 3, as you all know, of the Constitution lays down the fundamental rights. I don't want to elaborate on them any further, rather than saying that these rights, if violated by any statutory authorities, gives a cause of action for a citizen to knock the doors of the court under Article 226 of the Constitution of India, as far as the High Court is concerned, and insofar as the Supreme Court, it is Article 32. Now, we have to understand the distinction between invoking jurisdiction under Article 226 and Article 32. The distinction is, with respect to Article 226, which is before the High Court, it can be invoked in case of violation of both fundamental rights and statutory rights. Whereas, as far as Article 32 is concerned, it is confined only to fundamental rights. Now, I would like to illustrate I would like to go into the topic by illustrating certain examples. So, take for example, in a case where a person working in a government department is suffering from partial blindness and he wants to avail leave for certain health issues involving disability. At the inception, a representation has to be preferred to the head of the department or the leave sanctioning authority, indicating the reasons for taking leave, and the concerned government servant should also be aware of the statutory instructions governing the field for availing the maximum permissible leave. For example, in the case of central government servants, we have the CCS leave rules. Rule 12 of the said statutory instruction specifically provides that a government servant shall be granted leave up to a maximum period of 5 years. However, there is an office memorandum of the Government of India dated 25/2/2015, which states that the ceiling on a maximum permissible leave under Rule 12 may not be applied to leave on medical certificate applied in connection with the disability. Therefore, a representation preferred by a government servant seeking leave exceeding the maximum permissible leave as laid out in Rule 12 should always be accompanied by a medical certificate and should specifically refer to the above said OM. Therefore, a representation which is preferred to the competent authority should at the inception state the bare facts necessitating the medical leave and should emphasize upon the relevant OM, which exempts the ceiling limit as provided under Rule 12 of the CCS rules. The representation should, normally a representation should have the date and only a competent authority to sanction leave must be addressed. Whatever cases I have come across, the representations are not addressed to the competent authorities, but generally they are addressed to some authorities. For instance, I came across a case where a representation has been addressed to the ministers concerned and other authorities. Normally, when a representation has been addressed for a specific grievance, the competent authority would be the appointing authority in certain cases, and in certain cases there will be authorities designated for certain issues. For instance, I have seen a case in a matter which involved in one case, a representation was, I also want to emphasize on the necessity of AD and an acknowledgement which has to be there when a representation has been sent. Because in some cases, when I ask the clients about the representation which they have addressed to the authorities, they just give me a representation which doesn't have the date and which does not have the receipt, the postal receipt. In the sense, courts will normally, when a writ is preferred, they will normally look at the inception, they would look at the representation. So then they will check whether the representation has been sent to the concerned authority, has been received by him or not. For instance, when a writ of mandamus, which means a writ is preferred for seeking a direction, compelling the authorities to take action on a representation, the authority should have at the inception received it. So to that, we should send a representation with an acknowledgement. And the acknowledgement should form a part of the typeset of papers when it is filed in court. Only in those situations, the High Court will be, at the inception itself, the High Court will pass an order directing the authorities to act on the same. or else the High Court might issue notice, ask them instruction. This will take some time. And normally at the end of the day, it is very difficult, as you all know. MuthuSelvi had, at the inception when she introduced me, she said this case was over within the month, because this case which was given to me was documented very well. It had all the representations in order, and the client had basically worked on the very issue of how that he cannot be terminated, and all the relevant OMs were annexed, and the document, it was at the inception itself, the judge was very satisfied. Seeing his representation, reading the representation, he was very satisfied, and therefore it was only 2 hearings or 3 hearings. They necessitated the government to file a counter, and based on the counter, the court was very quick in taking a decision. Therefore, my advice to all people who are government servants, both in the state and the central government, you always have to send representations drafted by referring the relevant OMs, relevant statute, and it should always be accompanied by an AD, because that gives a cause of action for an advocate to approach the court. Only in those circumstances, the court will be vigilant enough to immediately act on those representations and issue writs. Now, there is yet another issue which needs to be seen in these type of cases. See, when normally representations are addressed to authorities, we need not immediately rush to the court seeking writ of mandamus or any other writs. The representations which are sent to the authorities can be followed up by the clients by sending applications under RTA Act. For instance, if certain representations are being sent and no reply has been received within say 15 or 20 days, an RTA application can be preferred to the concerned authorities. As you all know, there will be a public information officer in every department, and the public information officer is bound to answer on the action taken on the representation. Normally, when such RTA applications are sent, instead of waiting to give a reply, they will immediately act on the representation and they will send the action taken on the representation. This is one swift mode of getting a grievance addressed. Even after that, if the grievance is not addressed, then obviously you can prefer it. Then the next aspect which I would like to concentrate is on the point of limitation as to how much time you can wait till your grievance is addressed. Certain matters which I have come across, certain clients send representations again and again, and they wait for a considerable period of time, say for 1 or 2 years, and then when they are not able to achieve anything, they finally approach the court. For this, I would like to illustrate by, as far as central government servants are concerned, you all know that they have to first approach the Central Administrative Tribunal. In so far as the Central Administrative Tribunal, you have the Administrative Tribunals Act, which has a specific statutory provision, namely Section 21. This section gives the limitation which has to be followed while filing an application, original application before a Central Administrative Tribunal. Therefore, when a representation has been sent for any grievance, and if the representation is not being addressed within a period, say a period of 6 months, then immediately after the expiration of 1 year, as contemplated under Section 21, a OA has to be moved. Or else, there is a specific procedure. You have to move a miscellaneous application to condone the delay which necessitated for approaching the court belatedly. Therefore, I would like to advise everyone to be aware of this particular statutory provision, namely Section 21, which deals with the limitation. You cannot just simply make on representation and wait for a continuous period of 1 year and then approach the court. So therefore, the statute is very clear. Similarly, in cases where your representation is rejected, you have to be vigilant enough to approach the court and to basically for the court to invoke the remedy as far as CAT is concerned, section 21 is very important. In case of High Court, you have this, you don't have the concept of limitation, but it is governed by the concept of delay and latches. Say for instance, if you prefer representation and it is rejected, for instance, if it is rejected today, you can't wait for 1 or 2 years and go to the court, and you can't simply prefer representation again, and you can say you can't say a continuous cause of action is created, because Supreme Courts have taken a view that continuous cause of action cannot be created by merely sending representations after representations, and you have to approach the court within a vigilant enough. You should be vigilant enough to approach the court within a reasonable time limit. Now, coming to the concept of addressing a representation, I think I have already covered as to how a representation should be and what all it should contain. Now, I would like to share with you a matter wherein a client who was applied for a post. I had the occasion to deal with a case wherein a statutory authority had advertised certain posts for filling up the post of manager in a statutory authority. It had advertised in a notification. This particular candidate is a physically disabled candidate, and he had applied for the post, and knowing very well that the notification did not specifically earmark any vacancy for disabled candidates, he had applied for it and he had participated in the selection. And after he was not selected, he moved a representation, and then he filed a writ petition. My advice would be, at the inception, when the notification itself doesn't have the vacancy, doesn't contain the earmark vacancy notified for the disabled candidate, disability, you have the very cause of action to file a writ immediately. You have to immediately approach the court. This client had in fact participated in it, and then he filed a writ. I would advise you, when you see a notification and when admittedly there is no vacancy which is earmarked for disability, you can immediately approach the court, and the courts are normally guided by the statutory instructions and the statute governing the field. When the statute specifically says that the reservation should be followed even with respect to statutory authorities, then the court will be vigilant enough to pass an order of interim stay staying the notification. So in this case, he filed a writ belatedly, and no doubt that when notification is there, and when notification doesn't stipulate vacancies for disabled candidate, the act should be read into it. That is a different issue. But for immediate action, because this case, why I am illustrating is, this case was filed in the year 2015, and ultimately orders were passed very recently asking the authorities to consider the representation, and now it has been rejected, saying that these vacancies were not notified because it was earmarked for other. Anyway, the reason assigned is absolutely without application of mind. The reason which was assigned in that case was, for only 15 vacancies are notified, we would be implementing the result. This reasoning is very absurd. Anyway, we have challenged it, and it is pending before the Honorable High Court. But what I am saying is, when a notification is issued without earmarking the vacancies for physically disabled or for handicap, for other reserved categories, you should be vigilant enough to challenge the notification at the inception itself. Only in those situations, the courts will be guided by the relevant statute, and they will be in a position to grant stay. Subsequently, the government will be in a position to issue a fresh notification earmarking. Most of the governments, the statutory authorities, they are just advertising vacancies without issuing these, without earmarking these vacancies for disabled candidates, and the disabled candidates, they are not properly advised. My advice was, you should have immediately challenged it. So that is still pending, and I am taking that issue now. As far as the high courts are concerned, Normally there are normally the writs, as far as writs are concerned, you have the writ of mandamus. This writ of mandamus is being preferred normally when a representation is being made and when the statutory authority doesn't respond within a particular time limit. So the writ of mandamus is a writ which can be filed when a statutory authority doesn't respond within a specific time limit. So this writ of mandamus will basically compel the authorities to act on the representation. So as I already said, when there's a right, you can file a writ of mandamus. So when is the right created? You have to necessarily file a representation highlighting your grievance with the statutory instruction and all the relevant records. So this is a writ of mandamus. So when a writ of mandamus is issued, normally the authorities might consider it. Sometimes they might reject it. When a representation is acted upon and it is rejected, then comes a writ of certiorari. The writ of certiorari is filed to quash a notification or quash an order which is being illegally passed without applying a mine. So this writ of certiorari is sometimes accompanied by the mandamus also. So sometimes when you challenge a notification or when you challenge an order, you seek a consequential direction. So in those cases, you have the writ of certiorari mandamus, both are coupled. And then you have the writ of quo warranto. This writ of quo warranto is normally preferred when a public office is being illegally occupied and when the qualification prescribed is not being satisfied by the candidate occupying the post. So this writ of quo warranto is normally preferred in case of public offices, and for that, most probably you should be, before filing a writ of quo warranto. Normally, writ of quo warranto is not easily entertained by the high courts, and you should be armed with all documentary evidences to establish the fact that the appointment is totally illegal and it is made for extraneous consideration or color by excess of power is being made. So writ of quo warranto, you have to be very careful. You have to be vigilant enough to collect all the information under the RTA Act, and only when you are satisfied that the appointment is per se illegal, you have to approach the court. So this is the writ of quo warranto. So I think I have covered all the writs. Other writs are habeas corpus and everything will not be relevant for these type of issues. So in case of service matters are concerned, normally the writs governing the field are writ of mandamus, writ of certiorari, and when both are coupled, writ of certiorari and mandamus. Therefore, I think I have done justice by narrating whatever the basic things or as to how a representation should be addressed and the follow-up action which has to be taken, and till what time you have to wait when till the concept of limitation as far as the CAT is concerned, and so far as the High Court is concerned, you have the delay and laches concept. So therefore, when you approach an advocate, you should have all these documents in mind, and the documents should be like the representation should have the AD. To sum up, it should have the AD, and if possible, you should have the action taken on it. And if the action is taken on it, if you want to challenge an order, you should have the original of the order, because courts always insist upon the original order which has to be filed in the types of papers. In case you have missed it, you will have to file a petition called a dispense with petition. So dispense with petition is normally filed when you don't have the original copy of the order. So in those cases, the dispense with petition will be ordered, and then the courts will be then taking up the main issue. So these
Maurya, please talk about a legal notice also.
Legal notice.
What about legal notice also?
Yeah.
How to prepare a representation, what to keep, what facts to give, what is a petition, what is a counter, what's a rejoinder, or this. What does serving a petition mean? If you look into all these cases.
Therefore, with respect to legal notice is concerned, legal notice is normally the facts in brief should be stated in the legal notice. in the legal notice, the statute governing the field should be specifically mentioned. And normally, why I did not cover about legal notices, legal notice is normally prepared by advocates, and you should be vigilant enough to give all the particulars. Your role is to give all the particulars, the bare facts, the bare facts governing the field, and the advocate will be in a position to prepare the legal notice. The legal notice usually will have the bare facts, and it will have the statute with the relevant statute which governs the issue, and the legal notice will be normally the very same concept called, when we prepare a legal notice, the very same concept of AD, everything is required. And petitions, as far as petitions is concerned, as I already told you, with respect to dispense with petitions, I think I covered that. And counter is, see, when a writ is preferred, at the inception, the court will compel the government to file a counter affidavit. Normally, in case of mandamus, sometimes the court will be passing an order for the authorities to consider the representations, and direction will be issued at the inception. Sometimes when an order is under challenge, that is in case of certiorari or certified mandamus, a counter is mandatory for the court to adjudicate on the issue. Therefore, a counter affidavit is normally filed by the government opposing. They will basically, whatever the impugned order is passed, they will normally reiterate whatever is stated in the impugned order. Sometimes the impugned order might be 1 line or 2 line, it may be a cryptic order. In those cases, the government will try to justify the impugned order by narrating certain extra facts which have not been stated in the impugned order. This I would like to emphasize, because normally the impugned order should be a speaking order. It should have all the reasons to reject a representation. If the reasons which are not assigned in the representation are taken as additional grounds to support the impugned order in a counter affidavit, then it definitely can be opposed by way of filing a rejoinder. Rejoinder is normally filed when you feel the counter has gone beyond the draft. When you file an affidavit, and instead of answering the affidavit, sometimes the government may be clever enough to support the impugned order by way of lot of extra points. So normally, Supreme Courts have time and again held that an impugned order cannot be supplemented by way of counter affidavit. So the courts will normally see whether the impugned order is a speaking order. If the impugned order is not a speaking order, then the government cannot improve the impugned order by way of counter affidavit. Therefore, we have the right to file a rejoinder wherein we can specifically say that the counter affidavit has gone beyond the draft, beyond the impugned order, and the counter affidavit cannot be at the inception accepted by the court. So in those cases, we have the right to file the rejoinder. The pleadings are like, you have an affidavit and you have the counter affidavit which is filed by the government. You have the right to file the rejoinder. And in some cases, the government will also file the reply. So we need not be worried about the reply. Again, we have the liberty to file a reply to the additional reply. So these things are there both in high courts and CAT. Normally in CAT, they will give permission. You have to seek permission to file a rejoinder. Even in high courts also, this concept of rejoinder is there. But sometimes certain advocates, to just cut short the litigation and to get an order by way of, for instance, in the case which was assigned to me, MuthuSelvi initially insisted me to file a rejoinder. But at the inception, we have to be choosy in what cases we have to file rejoinder and in what cases we need not. Already in that particular case which was given to me, the law was very, very, very clear. A lot of Supreme Court judgments have taken a view that when you have acquired disability during the course of the employment, you cannot be terminated. Therefore, it was a clear-cut case for me. Therefore, I took the risk of not filing a rejoinder and directly arguing the case. And therefore, to cut short, because I would like to tell you the practical difficulty as far as courts are concerned. As far as courts are concerned, normally to get a matter listed itself, it is very difficult. Therefore, when a matter is listed, you should be in a position to, for instance, when a writ petition is filed before the court first issues, in case of certified mandamus, rule nisi notice is issued. So rule nisi notice is issued means the whole records have to be summoned by the court, and the government will have to file a counter, and based on which a decision will be taken. Normally, when notice has been issued, the next hearing, the matter will not appear. So it depends on the advocates as to what is urgency, and they have to insist upon the urgency, and they have to bring it before the court. Therefore, my advice is your affidavit should be specific, addressing a point, and if there is a counter affidavit which goes beyond the brief, you should be in a position to you reject the counter by way of filing a rejoinder. And then you coming back to the topic with respect to petitions are concerned, you have the writ petition. The affidavit is what you swear in the affidavit. The bare facts are stated in the affidavit, and you have the concept called interim direction. In cases where there is imminent urgency, for instance, when you challenge a notification, and in the notification we say that the posts are not earmarked for disabled, you necessarily have to seek a stay. In those cases, you will file a petition called a petition for interim stay. Sometimes you will file a petition for interim direction. Those petitions are filed to, for instance, you want to reserve a particular post for a particular candidate, for a particular, for instance, for a post of manager is concerned in a statutory authority, the post, if you file a writ, and if you don't get a direction for interim direction, then the matter will become infructuous. So in those cases, you file a petition called petition for interim direction, wherein the courts will be guided based on the prima facie case. They will be passing an order for interim direction to keep one post vacant. So these petitions are called interim stay petition, interim direction petition, and sometimes it is called interim injunction petition, restraining the authority from going further with the recruitment. So these are the petitions which are normally accompanied when writ petitions are filed. So they are interim direction petition, interim injunction petition, interim stay petition, and dispense with petitions, as I already told you, are filed to dispense with the original copy of the order. So these are normally petitions which are filed along with the writ petition. So then coming again to legal notices, I think I've already told you the legal notices will always be addressed to the concerned authorities. In case of statutory authorities, you have the CPC. The CPC very well specifically says you before filing a suit, you have to mandatory issue a notice to the concerned authority, and based on which you can file a suit. In case of, for instance, in case of private institution, you cannot file a writ. You have to necessarily file a suit. In those cases, a mandatory notice has to be issued to the concerned statutory authority, and based on which subsequently you have to file a suit. And as far as suit is concerned, you have the concept called plaint. The plaint is normally drafted very carefully. It cannot be compared to a writ petition. As far as suit is concerned, take for example recovery of you file a suit for recovery of your amount from your department. For instance, your employer has not paid you salary. Then you file a suit for payment of salary. Then the suit has to be very specific. The plaint has to specifically state when you join that department, when you join that private institution, the specific agreement which you sign with the employee, and the days, the time when you have worked in, and then when you are terminated, the date of termination, and till what time they have not paid you salary. Those things have to be very specific in the plaint, because unlike a writ petition where you can supplement by a reply affidavit, the plaint is like when you file a plaint, it is followed by the the concerned private establishment filing written statement. After written statement, the framing of issues will take place. Then you have the concept of filing proof of debit. Then you will be after filing of proof of debit, the concept of cross-examination, chief examination, everything happens. So this is something unlike a writ. You have to be very careful. You have to be very specific in drafting a plaint. You have to specifically give your advocate all the bare particulars. Like as I told you, every particular statement should be specific when you draft a plaint. So then, so therefore, as far as suit is concerned, this is with respect to private individuals, private entities where the concept of writ cannot be invoked. So this is based on the pecuniary jurisdiction. You can either file it in the, you have a hierarchy of courts in the civil side, and based on which you can approach the relevant forums. So this is as far as suit is concerned.
Maurya, please talk about public interest litigation.
Public interest litigation. So normally, when do you file a public interest litigation? As far as PIL is concerned, normally PIL is being filed for the very same concept of all the writs, the writ of certiorari, writ of mandamus, and writ of quo warranto. All these writs, if it is filed in public interest, the concept you have in High Court with respect to public interest litigation, there's a specific format which is mandated as per the High Court rules. So as far as PILs are concerned, you have to first mention how, see, normally as far as public interest litigation, the law is very clear. You need not state as to why, the reason for filing this public interest litigation, as to how you are interested. That is the concept of public interest litigation as evolved by the Honorable Supreme Court. In a number of category of decisions, the Supreme Court has taken a view that you need not tell your interest. It is only filed in public interest. So normally associations, even I had the occasion to deal with a lot of cases with respect to, I have done a lot of pro bono litigation with respect of certain fishermen associations who have approached me. This concept of PIL is being filed. So normally when you file a PIL, you have to state at the inception, the association registration, the association should be registered. If you're registered, the association's registration certificate should be enclosed. The association's PAN number and all the other details should be specifically pleaded in the first para. The second para should have the bare particulars about the cause of action. Cause of action in the sense, for instance, you take a case where notification is issued. Again, I come to the very same topic. A notification is issued by a government or as any statutory authority, and the particular individual is not in a position to come to court. Then an association can take up this issue, and they can file a public litigation, and they can very well take up the cause, and the bare particulars, namely, they have to state as to the registration certificate as a mandate should be filed in the paper book of papers, which is being now mandated as per the High Court rules. Normally we were filing typeset, now all A4 and paper book has to be filed. So in that paper book, you have the registration certificate. The registration certificate of the association should be annexed. Then the other documents should be accompanied. So as far as PIL is concerned, normally you don't state how you are interested, but in certain cases, the courts are saying that you have to state as to how did you come across this issue. That normally you can say that we have seen this in the newspaper, and based on that we are filing it. So basically, the cause of action should be narrated in the beginning. Then you will have to highlight the issues concerned as to the statute, again the statute governing the field, and then you have to indicate the violation by way of grounds. And normally in case of quo warrantos, you have to annex the RTA replies saying that the appointment is illegal, the records indicating that the appointment is illegal. So public interest litigations are normally filed in, but I would also caution you that in case of service matters, with respect to quo warrantos are concerned, normally they are not entertained. So public interest litigation, cannot be filed with respect to quo warrantos when service matters are specific, because a stranger cannot approach a court and cannot question a particular authority. He has to state as to how he is aggrieved. So now the concept called how a person is aggrieved comes in case of service matters. So service matters normally public investigations are not entertained. So therefore, as far as public investigations are concerned, you very same concept called the writs. The public investigations you involve the very same kinds of writs: mandamus, certiorari mandamus, and quo warranto. So these are the various writs which operate in the field of public investigation also. And normally these public investigations are filed come up before a division bench. Therefore, we have to be very cautious when such type of litigations are filed. We have to be equipped with relevant documents in the sense, as I already told you, we have to annex all the notifications governing the relevant statute, and the statute sometimes may be filed in the paper book, and we have to impress upon the court that we have come with clean hands, and we have all the weapons to demolish the impugned order or the impugned notification in case of those kind of cases are concerned. I think I now leave it to the audience to basically put forth questions if they have any other specific query. I think I have covered most of the areas. I think notices, representations, writs, petitions, I think I covered everything.
Thank you very much. Yes. Thank you very much, Mr. Maurya. If there are any questions, please raise your hand and you'll be unmuted. Any questions? It's a very comprehensive presentation, Mr. Maurya, covered all the technical. It's a very difficult topic. Technicalities are involved.
It's a very difficult topic, but I think this topic which I have taken and which I have narrated, I think normally when a person approaches the court, what all bad documents he has to have, and it is as a mandate, you need not approach the court directly. You can invoke the RTA. I think most of the people, they are directly approaching the courts.
Yes, that is a problem.
Therefore,
yes,
when you send an RTA application, they are okay. They are aware some representation has been sent and they immediately take action. This has happened in a lot of cases. Therefore, I suggest you to invoke the RTA Act in the beginning and then approach courts. And moreover,
in our case, we find an RTA against the private cottage for reservation, aided cottage.
Yeah.
They provided the reservation. So yes, it happens in many cases. That, so that is very much there. Any questions, please? Please raise your hand if there are any questions. Muthu, you want to say something?
No.
Anup, please
Yes.
unmute. Sorry. Yes, Anup.
Sir, good afternoon. Sir, out of curiosity, I'm asking this question. In 2018, I was harassed by one of state transport conductor. So what I did was I raised a complaint. I filed a complaint CSR with the police station, and I sent a letter to that branch manager also, branch manager of the bus depot. But after that, I didn't take any action about that. Then recently I got the paper back. That is the complaints, the complaint that I filed with the court, with the police station. The copy which I filed in my personal file. So I got that, and I sent an RTA request to the branch manager of the transport depot some 1 month back. But I haven't yet received any reply. I want to know, I'm curious to know what would be the course of action this branch manager will be doing.
See, when you file an RTA application, you are basically, I think you are basically sought the action taken on your complaint. So
Sir, so 1 minute. Sir, actually the complaint I filed with the police station in 2018. For that only I have filed an RTA right now.
So you have not got any reply till date, right?
Yeah, yes.
So there, but my question to you is, when you have preferred a complaint to the police authorities, how did you file an RT application before the employer, which is the transport authority? When I think you can maybe make a complaint to the statutory authority, that is the depot manager, whoever it may be, asking the concerned authorities to take action against the conductor. Then you can file an RT application.
Only
Yeah,
after
what,
4 years. After
sir,
4 years, it's fine.
Because
4 years is a
yeah, you
long
have
time.
filed a complaint before the
sir, I
police.
complained with the police
Yeah.
and gave the copy along with my complaint letter to the branch manager of the depot.
When
That's
did
what
you
I
get-
did in 2018.
Okay.
2018 May month.
No,
Okay.
but giving a copy, you see, there's a problem. Because unless the original addressee acts on it, person to whom the letter is copied does not write text. Copy is only for information. It is not for action. So if you want two authorities to act simultaneously, write to them separately, not copy. This is a big mistake people make.
Yeah.
They copy. When this copy, it's only taken to be information. If at all you want someone to take action, address the document directly. Isn't that case, Mr. Maurya?
Yeah, therefore, when a copy is being addressed, as you rightly said, it is only for the information. The authority may act or may not act. He may take disciplinary action. Therefore, you give a discretion to him. But whereas when you address a complaint directly to him, he is bound to take action. If he is not bound to, if he doesn't take action, by way of RTA reply, he might say, no, this is a report of the police, therefore I'm not in a position to take action. Sometimes he might take action also. If he doesn't take action, I mean, if you don't get reply, then you have the concept called first appeal, and then you have the concept called second appeal to the Information Commission. So these things are there. So the RTA Act is a separate mechanism under which you can redress your grievances. So therefore, you have to specifically make a complaint alleging the incident happened on so and so date. This was a person who harassed me and I suffered. So the mental agony which I suffered, and then you have to specifically ask the authority to take action on him. And then you can file a RTA application asking him the action taken on the said individual and the said employee. In those cases, they will be in a position to act. Whereas whatever you have done, even in your case, you have sent a copy to him. You can also now raise a complaint to him about the incident, and you can very well file an RTA application thereafter, and you can ask the action taken. Though it is too late, you can anyway narrate the incident, and you can file a fresh complaint to the depot manager and ask him to take action.
Okay,
But now,
sure,
Maurya, he'll be caught up in latches. 4 years.
The latches concept will come when you approach the court. I
Even
think
here,
now,
after 4 years, you can't make an issue. I mean,
after 4 years, definitely we can't make an issue. But one, we can follow up the police complaint. Till now, we have no clue as to what happened.
So even there, they would say, what were you doing for 4 years?
Yeah.
So you see, this
Yes,
is
sir.
important.
Sir,
We send
actually-
document, we stop. We should not do that. Secondly, Anup, remember, if there is a police or court matter, typically the civil authorities would not act.
Okay.
Typically, they'll say it's better than the police conspiracy or sub judice.
Okay.
So you can't use both channels together, administrative and judicial.
Okay.
You should not do that because you won't
Sir,
get the
actually, I
response.
want to. I was curious enough. What will be the mechanism? What will be the action taken? That's why I
No action
applied,
taken. It's a complaint by itself is only, again, unless you follow it up. If you're serious enough, you follow. After 4 years, nobody wants to believe you that you're serious about it. So let's be very honest.
Fail. So it becomes very difficult for them to carry out the investigation. That is
Sure,
what-
sure, sir. Thank you.
Right. So thank you very much, Mr. Maurya, for the very wonderful session on a Sunday. And that's the only day sometimes lawyer get. Even Sundays you don't get because you're so busy in preparing cases for next day. Thank you very much for sparing your time and be with us. And thank you very much for supporting AICB. We look forward to more work with you and through you and in Tamil Nadu and other states. Thank you very much.